whatever this is the other problem with the agreement, because I'm not sure, according to the lease, that they would be required, well, a couple of things. The propane that was purchased in 2024, right? That they used.
There was no propane purchased in 24. It was bought in the summer of 23 and the summer of 22.
Okay, so all they owe then for propane is $300.
But we did not use all that was in those tanks, Your Honor. There's still 900 gallons left.
Well, yeah, that's a whole other issue, but okay, go ahead with your questions.
In January, when we had our phone call, me reaching out about prorating the rent due to the continued violations of the lease agreement that you had not acknowledged multiple times in our previous calls. Did I come to you on the basis of the violation of the lease agreement in reference to wanting to prorate the rent? Was that, I mean, can you confirm that that was the nature of our conversation?
Conversation one side and Drew screaming for about 15 minutes. That's so I decided to let you go ahead and move out.
Do you have evidence what you just said of me calling you every name in the book?
My wife heard it all. You slandered her, my wife, my kids, everybody around my family. You made bad remarks about it.
Okay. Besides the point, the question that I ask you is, reaching out to you, was that not on the basis of the repetitive, egregious violations of the lease agreement that you had acknowledged but not taken any action on?
You violated more provisions than the lease. Only thing I've done is I did not get that bathtub taken care of. I was unable to get it done. It's the only thing that I've done.
Mr. Samanak, in regards to that question, do you not recall the videos and photos we sent you of all the pest infestations?
I never got a video. My phone does not receive them. If you send them on the phone, I did not get them.
Do you receive photos? No.
No.
Okay. Was that ever communicated to us? Okay, for sure.
Go ahead.
I have no further questions.
No further questions, Your Honor.
All right, you may proceed.
I have no further questions on this purpose.
Sir, is the house been listed?
No. It was put on Zillow for a few days by mistake. I was not.
By mistake?
Yes.
How did
The
that?
lady that put it on was going to help me, and she thought misunderstood what I told her. And
She was gonna help you do what?
try and list the house for rent. And there was too many things that I needed to do, and I told her that I don't want to do it. She said, well, it's already on, so we'll take it off. She did.
When was that?
Sorry,
When was that?
don't have the exact date, but probably a week or two after they moved out. Moved out the 1st of May.
Do you have any pictures of the current status of the painting?
I can tell you the 3 rooms that were.
Do you have a receipt for the purchase of any materials regarding the painting?
Spent approximately $300 at Menards.
I'm going to go back over these figures you're indicating your own. You're saying that they owe you $1,200 for May and April.
Each, yes.
Total of 20
April.
March and April, $2,400.
Yep.
How much are you claiming for propane?
1,800 this month.
1859 or 1889,
Yes.
and then 293.66 for electric. Those are all your claims.
Well, the paint,
And the painting is how much? 17, how much?
I don't have the exact amount, but the labor is gonna be 17 or more.
What do you mean you don't have the exact amount?
They've already used up about 1,700.
Do you have a canceled check, anything that tells me that that's what you paid for painting? Pardon?
I do not have an answer.
How'd you pay them?
Give them credit. It's the only money.
Dear goodness. So the person doing the painting owes you money.
Yes,
And so they're supposedly doing this work, and then you're going to take it off of their bill.
yes,
So there's been no outlay of any monies from you to a person to paint these premises.
yes.
And I don't have a bill for paint. I don't have a bill for any of that, right?
Get an estimate for the, like,
Whatever that is, I don't know who created that estimate.
I have a second estimate that's higher than that.
I don't know who it's okay. It's not the way this works. You're telling me that it's 1,700 for that. But you haven't paid that.
Yeah.
Well, that's not my question. You have not paid that, correct? You're saying that you bought supplies at Menards, but I don't have a receipt for that, right? So in reality, I have nothing here today that tells me anything about the painting other than what you said, right? Any additional witnesses for the plaintiff?
We have no further witnesses at this time.
Yes.
All right, before I hear from the defendants, and I don't know if I'm necessarily going to need to hear from the defendants unless for whatever reason plaintiff wanted them called, because folks, now I don't mind coming back and making the ruling, but I think the parties should try to figure out if they can resolve this without screaming and yelling at each other, and I'll give that opportunity because there's some agreement to pay half the rent. One party's claiming it's because of stuff that wasn't done on the premises. The other saying it was continued upon this propane bill, which I'm not sure that propane bill is owed. Outside of that, whoever drafted this lease, and this lease, counsel, as I'm sure you're aware, any ambiguity in that lease is going to be construed as against your client. And so I think you need to look at that language very closely because it's his lease.
I understand.
And so there's that part of it. The other, and those ambiguities, just so that the parties are clear, are the premises that's leased and interference with that premises, because it got a problem in that initial paragraph.
But there's no part of that lease refers to anything in the way of quiet enjoyment and use of the premise.
Except by operation of law.
I understand.
I mean, even if it's not in there. Okay, well. So I'm going to tell you what, I'm going to try to handle some of these other cases. You guys, if you guys can talk to each other civilly, need to go out and resolve it. There's 1,200 sitting in a security deposit. I have a paint job that I'm not even sure is done or is going to be done that isn't going to be paid, that somehow or another is on some credit. I've got property that they lease, which by the leasing agreement itself says they lease that whole thing. And then, goodness help us all, we have paragraph 5, which is the most confusing provision regarding the payment of propane. And if you guys want me to give you my decision on that, I'll be more than happy to. But I think you guys probably should see which way the wind is blowing, go out there and try to negotiate something. If not, you'll get my call on it. I'll break on this case. Everybody else that's waiting, you got to give me about 5 minutes. I will come back, I promise. Maybe. All right. Court's going to stand in recess.
All right.
Were the parties able to try to talk at all, or do you guys just didn't?
Unfortunately, we cannot resolve the case, Your Honor.
Okay. All right. I think I understand defendant's position unless you guys wanted to testify about something. I don't think I need it necessarily to come to my decision. All right. Closing arguments.
Your Honor, we have a lease agreement here that it seems as if both parties are having difficulties in interpreting that lease. But the lease is clear that changes have to be in writing. We feel that the testimony has been sufficient for the court to award a judgment for the unpaid propane. We believe the unpaid amount is $1,882, unpaid electric of $293, rent for 2 months, March and April of $2,400. And then we have the issue of the paint. If the court wants to disregard giving the plaintiff any money for repainting, as long as we got the propane money and the back rent and the electric utilities, we would be satisfied. There's no provision in the lease that says they're going to have quiet enjoyment or exclusive use of this premise. There's been no testimony given to the court as to why they should not pay the 2 months worth of rent. There was testimony that Mr. Samanak at one time said if they paid the propane, he would reduce the rent. The propane bill has not been paid. Even if you interpret the lease as saying that they only have to pay the propane bill on December 31st for propane that was delivered that year, there is still an unpaid balance of propane owing. So I would ask for a judgment for the expenses as we stated there. And then you could give them credit for their $1,200 in the security deposit.
Closing argument.
Your Honor, we do not feel as if we owe the propane due to the prorated rate of over 900 gallons still being in the tanks. With the $1,400 payment due, which would null and void his claim of the rent, which we have satisfied per our agreement in January. And we dispute the charges as well.
Your Honor, the entire basis for this was reaching out to the plaintiff in January due to multiple egregious violations of the lease agreement. The plaintiff has been unwilling to, and his attorney, to review the evidence, the severity of what's occurred and why we had reached out in the first place in January to prorate the rent and facilitate an exit of the lease. In this case, we do not feel that we satisfied the rental payments in full, in accordance with what we agreed to in January. That rental, prorated rental payment was not predicated on propane payment in any way, shape, or form. Multiple parties were present for that call, and I would say that all of them can attest to the fact that nothing of that nature was said, nor did I personally agree as a party on the call to those terms, those verbal terms. So we do feel that we have satisfied not only the rent, but the propane requirements as well. We do feel that there is unaddressed matters with the violation of the lease agreement and why we had initiated all of this in the first place, but recognize that there's a time and a place to address those matters as well.
And we move for our deposit to be paid back to us in full.
All right. Court has listened to the testimony and read the pleadings, and frankly, the defendant's position is rather straightforward. They acknowledge that they owe the 293, I think it was 293.66, which are the utilities. So that's the easy one. The next rather easy one, but the court's going to make its own finding on this, and that is that the what both parties agree on is that for those 2 months there was an agreement for basically a 50% rent reduction. One party says it's because of what were the conditions of the premises and regarding use of the premises, that being the defendant. And the plaintiff is indicating that the reduction came because of, or if the defendants, the reduction would take place and the defendants were to pay the propane, but had somehow not done that. And so therefore he considered, as his words are, he considered the agreement void. I have to say, when the court analyzes that, the plaintiff's position makes no sense. I don't know why I would give a reduction in rent for somebody to pay me another bill or outlay in cash. That just doesn't make any sense. What I think is that there was some dispute between the parties, and the court would find that was more along the lines of what the defendant is claiming. And I find that their statement regarding that is correct. I don't believe that this propane was of such an issue that it would require the rent to go down. If one's not paying what in effect may be a utility, why would I reduce their rent so that they could pay me that? Again, that makes no sense to me. And so the court believes that for those 2 months that the defendants do owe $600 per month, but the $1,200 for those 2 months. I would indicate that and I'll put it this way. My other reason for finding that regarding the reduction in rent is the same confusion that comes from the lease itself. The lease itself, and this is why people should probably have attorneys draft leases for them in full and fully understand its implications, because that lease leases that whole premises. That whole address is leased. So there's that. So the court does believe that they owe that $1,200. Yes, ma'am.
Sorry, we did fulfill that in February when we paid January, February, March, and April to Mr. Salmonak.
So you paid the $1,200?
We paid $2,400 to him for those 4 months and the 50% reduction.
Got it. Okay.
So we've already satisfied.
You already paid that. Got it.
Your son-in-law Harvey Proctor came to.
I don't need to know all of that.
Sorry.
She answered my question. Are you two married yet?
3 months.
3 months you get married? So by that time, you're going to learn to keep your mouth shut after she speaks?
I'm getting.
I hope so. All right. Maybe you'll get it. All right. So that I want to make sure I'm clear, does plaintiff agree that that $600 was paid?
Well, Your Honor.
I'm not looking for full argument. I'm just saying, did they pay the rate at $600 for those months?
But for those 2 months, but if you look back at January, the $600 from January forward.
I'll take that as a yes. I'm done. So I don't really need to do anything with that because I think that they fulfilled the $600. The plaintiff himself stated that whatever that agreement was, he just said they didn't fulfill and then unilaterally decided that they had breached the agreement. And so now is going to charge them. It can't work that way. And it won't work that way. And the court's not going to enforce that to happen. Particularly when now he's here attempting to try to sue for the propane that he wanted them to pay, which some of that, quite frankly, given the lease, they don't owe. Now comes the really, in this case, well, let me just deal with one other issue. So I've dealt with the rent. Quite frankly, I believe that the defendants have satisfied the rental provision as outlined and as amended by the parties. As to the electric, they admit that they owe the electric, just so that we're all clear. In regard to the painting, I'm going to say this, and I'm going to try to put it as gently as I can. I have some issues regarding credibility from the plaintiff's side. And the issue that I have regarding that credibility is that it was very clear that the court was led to believe that there had been some outlay of cash, and I will have my recorder go back, about payments that he made in the amount of $1,700. Not true. I don't have a receipt here from Menards. I don't know if that's paid, but I certainly have questions about the plaintiff's credibility to this court. It wasn't until later that it turns out there was no payment in part on this paint job, that it was credit because that person owed him. That's a whole different scenario than to say, I have paid this money. And I think it was quite honestly a direct attempt to mislead this court as to what was actually transpiring. And so I don't believe that plaintiffs owe anything for any painting. When I look at that provision, one of the ways to interpret that provision regarding alterations and decorations, and because of the last portion that everything then belongs to the landlord. If it were a decoration, decorations don't belong to the landlord typically. They belong, unless, well, until such time as they become a fixture to the premises, that's when they become the landlord's property. Otherwise, they could be removed by the tenant. So theoretically, under that provision, had they hung a painting in the place, it all of a sudden belongs to the landlord. I don't think that that's the intent. I also don't know what occurred with this painting, but it doesn't really matter to me. I think, quite frankly, that the plaintiff lied to the court, or at least misled the court or tried to mislead the court as to what he paid. And I'm having no part of that, and I'm not going to award any of the $1,700, anything for the painting in that regard. With regard to the propane, propane amount, which is, and again, this is why people should have leasing agreements, at least looked over by attorneys regarding this. At least once a year, presumably, there is this purchase of propane. Now, I mean, it's rather clear. Propane shall be purchased by the landlords once per year and shall be reimbursed by the tenants as soon as possible each year, but not later than the 31st of December of the year propane is purchased. So I can understand what plaintiff intends to do or is trying to do with reference to that propane, but he's stuck with his lease. He's stuck with his document. He's negotiating parts. I mean, it's a very strange thing because according to the language here, I mean, I understand they measured it at the beginning. There's supposed to be this other credit at the end, whatever. The only thing by the terms of this lease, the only amount that the defendants would have to pay would be the amount paid in 2023. And they owe that. We can talk about credits, we can talk about whatever. None of that matters realistically, right? And the reason why this is a bad way to do it is because the next tenant is really the one that benefits from what you've done. That's part of the problem. But that next tenant also could have had a deficit to what you've done. The fact is, you guys didn't use enough propane to make it even for you. That's really what happened. And maybe that's the risk in having this type of an agreement. I don't know if that was the intent of the parties. I'm just taking the plain language of what's there. That propane bill. So what they owe is just the propane and only the propane purchased during 2023. And that is an amount of $1,737.34. They paid $1,400 of that. So the net effect of that is, I got my math correct here, is that there is $337.34 owed. Whether you left propane in, what you had in, not part of what I'm looking at here in this case. So they owe the plaintiff that amount plus, Emily, you're going to have to help me with my math here, $293.66. I'm actually going to come to an even number. I hit one. Yep. So the plaintiff owes, or the defendants owe to the plaintiff $631 in utilities and propane. They have a security deposit. While I thought maybe there might be an issue with the doubling of the security deposit, they haven't complied with the part of the Landlord-Tenant Relationship Act regarding the security deposit in terms of the notification, the written notification, which can occur in different ways now, but the written notification of forwarding address. They may have known where, they may have known any of that, but I don't think that's been done, and neither do I think it's properly been pled, although it becomes an issue in the case. But 1,200 minus 631.
$569.
569. All right. So the net effect of all of this, after hearing all of the testimony, is that defendants owe plaintiff $631. There's a security deposit of $1,200. The court's going to order that I won't put it in the form of a judgment. I'll put it in the form of an order that if not paid within what would be 15 days, that it would then become a judgment, which the defendants could enforce, that the plaintiff must pay to the defendants $569. That's the judgment of the court. Counsel for the plaintiff will prepare for order.
Okay, Your Honor, just so I'm clear on this now, there's also the cost of $190.
You have to prevail on your claim.
Pardon me?
I'm not going to award costs. I don't think you prevailed.
Well, we have the filing fee, we have the service fee and the motion fee.
How much do you want the cost, counsel?
Okay. So you're saying we're not entitled to the
I am not awarding costs, but what do you have as the total amount of the cost?
We have,
Because quite frankly, I think, counsel, this matter should have been resolved between the parties somehow and or another, and has been an absolute waste of time
Your Honor,
for all parties.
I've practiced law for 49 and a half years, and I've settled every case that could be settled. These people thought they were owed.
I don't care why, because I now rendered my decision, counsel.
Okay.
I'm just letting you know. I think it was a waste. I just think it could have been resolved somehow. How much are your costs, counsel?
The costs are $190 for a service fee, motion fee, and filing fee.
Parties will split that cost in the case. You take $100 off of whatever I said is owed, and then we're done. So it'd be $469 coming. I'm done, folks.
Can I ask one question? I'm so sorry.
Probably not, but go ahead.
I just want to know, are we paying him anything or is he paying us? Or
He's got to pay you $469. If he doesn't pay it within 15 days, it will be transformed into a judgment that you can enforce.
Understood, sir.
Okay.
So that nobody has a judgment against him. Thank you.
Thank you, Judge.
This civil court proceeding concerns a landlord-tenant dispute arising out of a residential lease agreement entered into in late December 2022. The plaintiff, the property owner, testified that the defendants entered into a rental agreement for a house and an attached garage with monthly rent set at $1,200. The lease did not include barns, farmland, or other outbuildings, which the plaintiff stated were separately used by farmers and neighbors. A key issue in this case involved propane fuel stored in 3 tanks too, 1,000-gallon tanks and one 500-gallon tank, which had been filled by the plaintiff in the summer of 2022 at a lower seasonal rate. According to the plaintiff, the tanks were measured shortly after the defendants moved in, and the amount of propane present was recorded. The plaintiff testified that the defendants were expected to reimburse him for the propane they used, though he acknowledged there was no requirement that payment be made immediately and that repayment was to occur gradually. He stated that despite this understanding, the defendants made no direct payments themselves, although their parents later made 3 payments of $500 each, after which payments stopped. The plaintiff claimed that after adjusting for remaining propane in the tanks at move-out and crediting the payments made, a balance of approximately $1,892 remained, owed for propane. The plaintiff further testified that during the tenancy, the defendants painted multiple interior walls and doors in dark colors without approval and left the work incomplete. He claimed the repainting required multiple coats to cover and that the cost to restore the house exceeded $1,700 in labor and materials, though he admitted the work was still ongoing and that he had not paid cash for the work, instead relying on an informal credit arrangement with the painter. Photographs taken after the defendants moved out were introduced, showing partially painted walls and doors in unapproved colors. The plaintiff also sought unpaid rent for March and April, totaling $2,400, as well as unpaid electricity charges of approximately $293. He asserted that while he had temporarily agreed to reduce the rent by half, the agreement was contingent upon continued propane payments, which he claimed were not fulfilled. The defendants challenged these claims through cross-examination, focusing heavily on ambiguities in the lease. They questioned how propane charges were calculated, noting that Section 5 of the lease stated that propane would be purchased annually by the landlord and reimbursed by the tenants no later than December 31st of the year the propane was purchased. The defendants argued that this language did not clearly obligate them to pay for propane purchased before the lease term began, particularly propane purchased in 2022, before their tenancy started in January 2023. They also emphasized that more than 900 gallons of propane remained in the tanks when they moved out, raising questions about whether they had actually consumed the amount being claimed. Additionally, the defendants argued they were never provided with a clear written statement of what they allegedly owed until litigation began, making it impossible to know how much to pay earlier. The defendants further testified that the rent reduction agreement was based on repeated lease violations by the plaintiff, including interference with quiet enjoyment of the premises. They claim that multiple third parties, including farmers, neighbors, and equipment operators, frequently accessed the property using the driveway, contrary to their understanding of the lease. The defendants maintain that the rent reduction was negotiated to facilitate an early exit from the lease due to these ongoing issues, not as leverage to force payment of propane. They also disputed responsibility for repainting costs, arguing that the plaintiff failed to produce receipts, paid invoices, or testimony from the individuals performing the work, rendering the claim speculative and unsupported by evidence.